Thank you for returning February 9th, 2023. And our first witness in the second half of the meeting, where we take up S36, workplace violence in healthcare facilities, is John Wallace. John, thanks for joining us.
Good morning, Senator Sears.
Have copies of your memo. Fire away. Or perhaps I should introduce the committee to begin with. Senator Norris.
Good morning, Senator Bob Norris, Franklin County.
Senator Tanya Vyhovsky, Chittenden Central.
And Dick Sears, Bennington County.
Senator Nader Hashim, Wyndham County.
And Senator Phil Bruce, Chittenden Central.
Good morning, and thank you for allowing me to testify this morning. My name is John Wallace. I'm a healthcare attorney at Primer, Piper, Eggleston, and Kramer, and I represent the Hospital Association. But I'm really testifying today based on my previous 18 years of experience as an in-house hospital attorney and compliance officer, and I just wanted to share my experience in dealing with law enforcement from a hospital's perspective in relation to instances of violent crimes that have occurred in hospitals. I've spent a great deal of time interacting with law enforcement, developing policies and training for staff to make sure that we are balancing our obligations to protect patient rights and comply with the law, but also to try and maintain a safe workplace. And I believe S36 provides an important framework for healthcare providers and law enforcement to be on the same page in responding to violent crime. As Senator Sears has indicated, I have proposed language to address some of the concerns that were raised about healthcare providers disclosing information to law enforcement following an instance of a violent crime. The witnesses that testified previously were correct that HIPAA does create a barrier for healthcare providers to disclose information to law enforcement in some instances. What the proposed language is intended to do is to require healthcare providers to communicate necessary information to law enforcement to keep everyone as safe as possible. That a healthcare provider would be required to indicate whether a person is medically cleared and safe to leave the hospital, if that is the right disposition for that individual. And the healthcare provider would also be required to communicate other information that is necessary to safely assume custody wherever that custody would occur. There was discussion about HIPAA and the applicable exceptions to allow disclosures of information. And the most relevant exception would be disclosures required by law. And that's why the language proposed seeks to use that exception by requiring healthcare providers to disclose necessary information to keep the individual safe. There was also discussion regarding disclosures necessary for law enforcement to investigate the crime that occurred. There is an existing exception for disclosures associated with crime on the premises. That exception that exists under federal law is adequate to investigate crimes that occur in any healthcare setting. So there is no need for the legislature to act to address those type of disclosures. But what's new that was raised at the previous hearing is there would need to be some change in federal law to so that healthcare providers could disclose the information that's necessary.
Senator Vyhovsky has a question, Mr. Wallace.
What is the reason that your proposed language is requiring disclosure rather than allowing disclosure?
Because that's what the exception that's included in HIPAA requires. It allows a healthcare provider to disclose information where it's required by law. And so it's up to the healthcare provider to determine if they want law enforcement to respond to a violent crime that occurred. And if they do, and they want law enforcement to do something in relation to that patient's custody, to do so, the language would require them to disclose the information that's necessary to safely relate to that patient.
Sorry.
If, and as what happens in most cases, where law enforcement is called solely to investigate the crime, then those disclosures are not required. It's just where they're asking law enforcement to investigate the crime. In that instance, because that exception exists, it allows or authorizes, as you indicate, allows the healthcare provider to disclose the necessary information related to that crime.
Right, and I think that's what I'm getting at, because I see the exception, it says they may disclose, but your language explicitly says they shall disclose, as opposed to aligning with the language that says they may disclose.
Right. And that requirement is solely to allow the law to avail that exception that exists under federal law.
That's, go ahead.
Actually, Eric, can you help me understand the important, why it is shall as opposed to may?
Okay, so under the HIPAA law, they have this list of exceptions, and the exceptions kick in when it's okay for healthcare providers to disclose this information. One of those exceptions is when disclosure is required by law. And the cases have said clearly, it can't be just a may. It's
Okay,
got to be a shall.
okay,
And so if you have a state law that says disclosure shall be made, that qualifies under the HIPAA exception. So in that case, the information can be provided.
got it. So the shall actually triggers the, okay, thank you.
So let me try a different scenario and so I better understand. The hospital has finished with a patient in the emergency room. The patient says, I'm not leaving. I still feel like I need something. And the hospital says, we've done everything we can do. You're fine. And they call the police. They're not calling to arrest. They're calling to have this person removed. They haven't committed any crime or anything. Is there anything there that would require, they're not accused of a crime, they're just refusing to leave. Is there anything there that would prevent the hospital from saying, we've done everything we can for this patient, and it's time for him to leave?
Under those circumstances where there's no potential crime, then the hospital would not be able to disclose information regarding that individual. They would not be able to say that the individual is cleared, medically cleared to be discharged from the hospital. However, if the person is potentially charged with unlawful trespass or disorderly conduct, and if the law enforcement officer may temporarily take the individual into custody to remove them from the hospital, this proposed language would require the hospital to disclose the limited information that's necessary for law enforcement to take them.
Technically, in this scenario, the hospital, I believe it happened the other day, but technically in this scenario, the hospital would have to divulge with the law enforcement officer that they felt this person was medically cleared because there's nothing more we can do.
Correct.
Well, if the person has already been discharged from the hospital and is not leaving, I feel like there can be a reasonable assumption they've been medically cleared, they've been discharged.
Well, I know, but I'm trying to understand the.
Yeah, I know, I hear you, I'm trying to understand, I don't know. I'm sorry, that's not my job.
I just wanted to chime in. I think that delving, starting to move beyond what we're talking about with disorderly conduct and threatening and going into just the unlawful trespass territory, I think kind of starts to muddy the waters on this bill. And I feel like this is something that just should remain narrowly focused on violence being committed in the hospital.
Understood, but I'm trying to understand the disclosure requirement. So if you could only disclose that if they're committing a crime, what do you do when they're presumably not? Can you say anything?
Well, if they're not committing a crime, I don't know that the police would be called.
Well, they were. I don't either.
Yeah.
Yes, there would have to be some trigger that would allow the hospital to disclose information to law enforcement. And what's addressed by the proposed language is it would be limited to a situation where the patient has potentially committed a crime.
Well, this is very helpful. Are there other questions for Mr. Wallace? Yeah, thank you very much. Next witness is Mike Fisher, healthcare
Thank you, Senators.
from Vermont Legal Aid.
Mike Fisher, healthcare advocate. We changed the name not too long ago because nobody knew what an ombudsman was.
Or how to say it.
Just an advocate now.
Just an advocate. Yes, I'm Mike Fisher. I'm the state healthcare advocate, which is a position that's defined in state statute, but is contracted to a private nonprofit, Vermont Legal Aid. So I work for Vermont Legal Aid, but I have this role of being the consumer advocate around healthcare. So thank you for having me come in and say a few words. Trying to collect my thoughts here. First off, I really want to honor and respect the perspectives of the healthcare community that's come forward. I think it's real. I think that that it's a particularly hard time to serve the public right now. And I think that for whatever reason, people are easier to move towards violence and threatening behaviors towards people who are there to take care of them. It's a hard time. So I don't want to minimize that in any way. And nor do I want to speak against the bill. I'm not here to speak against the bill. I recognize your need to respond to the sort of the plea for help. And I recognize you're going to do something to respond to that. You have some concerns. But first, also you should know, I work at a law firm, but I'm a social worker. I spent 27 years in the front line serving in rural Addison County, working with people who are sometimes hard to serve. And I know that when people feel a loss of control in their lives, or experience fear for their safety or for the safety of those they love, or feel like their needs aren't being attended to, like they're not being listened to, that there are a lot of people who move towards behaviors that are really hard. And I would suggest that those are dynamics that happen in the healthcare setting, particularly in the VT. So I wanted to sort of set that, and I also I want to recognize that a dynamic in this business is that you'll never hear from a healthcare facility that will say, you know, we didn't meet that person's needs, we didn't treat them with respect, we didn't respond appropriately, didn't de-escalate, we weren't fair to them. You'll never hear that. At Legal Aid, hearing from patients, we do hear that. We hear that perspective all the time, and I have no doubt, even in really high functioning healthcare facilities where people are doing their darndest to treat people well, people still have the experience of not being treated fairly. And I have no doubt that across the hospital system, there are probably facilities that are cutting edge and doing a really good job here. And there are probably hospitals that are not doing such a good job. And so I mention all that to recognize we're setting a standard that can be used anywhere. And that's challenging. Add to that, I have to mention race and ethnicity and other areas of difference. Perceived threat is a tricky word. This is a human business. And even places that are doing their best to train their staff and educate their staff about these dynamics, I'll say it would not surprise me one bit if after this bill is passed and in 3 years and we looked at who was used on that there was a differential as to who the bill was used to, who this procedure was used to ask for help. It wouldn't surprise me one bit if we saw more BIPOC promoters being arrested in this way. And that's in note, I want to back up. I'm not singling out healthcare facilities as being worse than any other place. This is a dynamic that we live in. Another point I want to make is that I think I've tracked every witness you've had, so correct me if I'm wrong. I think you've heard from emergency EMTs, and you've heard from hospitals. I don't think you've heard from any other healthcare facility, healthcare provider.
I think we've heard from ambulance.
Yeah.
I have informally heard from nursing homes and other long-term care facilities. They were in here. So I understand their problems are similar.
I'm not here to, I wouldn't dispute that there aren't similar problems in other healthcare facilities, but I think, when this discussion started, the very first set of questions were, what kind of protocols are you using for de-escalation? And you heard from hospitals about the training and whatnot that they're using. And I would suggest to you that the dynamics, both in an emergency, with the first responder and in an emergency department are different from other healthcare facilities, different from your regular doctor's office. And so I say that because the bill frames the use of this, I think, quite broadly. And it could be used, I think, correct me if I'm wrong, at a regular doctor's office, and I would ask you to consider whether that's needed. I think the dynamics of the requirement of an ED to stabilize people and the requirements of a first responder to respond to whoever's calling for help makes it different from other healthcare facilities.
In a healthcare facility, whether it be a doctor's office or wherever, other patients are presumably there. And when this person's acting out in a manner that interferes with the treatment of that other patient, don't they have rights too? Don't you represent them as well?
Well, sure. I just think that the other,
some of the people you represent may not be getting treated because another person that you represent is acting out in an appropriate manner.
Yeah.
And it's a double-edged sword.
It is.
And I would point out that, at least in Bennington, when I met with the emergency room personnel, one was a person who is of color. She reported having somebody yell at her with the N-word 30 times. She reported getting attacked because of her race. She reported all kinds of racist taunts from patients. And, her response was, I wonder, what should I do the next day? Should I come back? Another person was gay, and he reported similar homophobic taunts, but also being questioned manhood, etc. So you brought up the BIPOC community and others. There are members of that community who work in our healthcare facilities that are being attacked because of their race, ethnicity, or sexual orientation.
So Senator,
It cuts both ways, Mike.
so thank you. That is why I came here at the beginning and said I'm not opposing the bill. That is why I came in here in the beginning and said I understand the desire to have this. I'm also suggesting there are some risks. So and striking the right balance is tough here. People who are hard to treat and who behave in ways that are dangerous or offensive are still people who need care, and that's the challenge that we have. I think I'll just finish with I'll finish with a recognition that the three areas of that this bill focuses on: simple assault, criminal threatening, and disorderly conduct. I'm not going to raise any concern about the first two. I fully understand that when behaviors raise to a certain level, hey, we need more nurses, we need to not be threatening. I do have some concern.
Thank you.
You have some concern about the broadness of the disorderly conduct category. And I asked the question without having a clear answer myself, which is not good, and witness should have come with a proposal. But what are the guidelines or the, how could we frame the disorderly conduct behaviors in a way that would make it feel more comfortable, less at risk for people being mistreated because they're making too much noise. So I think that's the challenge in front of us.
So I appreciate your testimony. It's always tough to find balance in these sorts of things. For the disorderly conduct part, there is, sorry, I thought I had to build it there, but there's the line referring to disorderly conduct that interferes with the provision of medically necessary healthcare services. So, obviously shouting if the person's in pain or if the person's having a mental health situation, I wouldn't say that it rises to that level, but disorderly conduct to the point where you're throwing a chair at another patient and disrupting their care, or assaulting another patient, or a nurse providing care to that other patient, I think it would rise to that level. Do you have any thoughts on that additional language that is comes right after that?
Yeah, it still feels to me like there's room for judgment call in there, and that it leads me to have concern about it being used differentially.
Yeah.
Yeah, well, and I'm just gonna restate, I too have concern with the inclusion of disorderly conduct, even with the line, I think there's too much room for judgment, which of course leaves room for bias.
It is disorderly conduct. Yeah. How's it defined in court or definition section?
Every once in a while, I anticipate a question.
I knew you would.
No, I'm not, only occasionally. Here, so I copied off the statute so we can look at what the definition was. There's extra copies for the witnesses as well.
I might have freed you up for this with my repeated concern.
That was what I thought of it. Yes, I appreciate that segue. digest the language. But yes, so the way the bill is framed is that it would have to be probable cause that a person has violated this statute. Violated this statute. Committed a violation that interfered with the provision of medically necessary healthcare services. So it would have to be one of these 5 violations of the disorderly conduct statute that interfered with that provision of services. And so they'll say that if the person acts with intent to cause public inconvenience or annoyance, or recklessly as opposed to intentionally creates a risk thereof, they engage in one of those 5 things.
So with banging on a vending machine because it didn't give you your Coca-Cola bottle, be considered disorderly conduct. I actually witnessed that when I was at the Albany Medical Center because I was sitting near the vending machine. I don't think they were very disorderly, but they were frustrated they couldn't get their soda out.
So just a thought on this, when we're,
Dr. and Eric?
Sorry. Oh, well, on your fact patterns that are used?
Yeah,
Yeah, I mean,
I
I
mean,
think.
they're not necessarily harming anybody else, they're just frustrated with the vending machine.
Is that recklessly making unreasonable noise that interferes with somebody's services?
Yeah, I don't think so.
It's big that a law enforcement officer wouldn't view that as probable cause for a crime, but technical reading of the language is theoretically possible. Say it's going to be a law enforcement discretion. I don't know, like,
By the way, it wasn't me.
yeah, I assume.
It wasn't.
Yeah, one point I wanted to make is, when we're looking at the intent, when we're looking at disorderly conduct that rises to the level where it interferes with medically necessary healthcare services, I almost feel like that would end up also being covered by simple assault, because, I mean, what type of unreasonable noise is going to disrupt healthcare services to somebody else? I mean, I feel like you have to engage in fighting or tumultuous behavior to the point where it disrupts the healthcare of another person. But that type of behavior could also most likely be covered under simple assault, or having the fear, the fear provision of that, or because you can be placed in fear of an assault and have it also be considered a crime and not actually have to incur any physical injuries.
So we're talking about this particular crime here. I guess, and Senator Bluski said something about bias. I mean, you need to explain that to me. Someone is either in a room creating a scene or not. Where's the bias coming into play?
The bias comes into play. So if I am someone who, because of my own bias, is more fearful of a certain type of person, I may respond by saying, when that person is doing a certain thing, that's disorderly conduct. Whereas if another person that doesn't have that same identity is doing the same thing, I'm not inherently as fearful. And so I say, well, that's not this. And so I'm not going to call.
Well, I understand what you're saying. However, it's the person who is calling the police. These individuals are going to show up, and I can only assume have some common sense. Everything's not black and white. Interview all parties involved and so on and so forth. Just because you call doesn't mean there's been a crime involved. Okay, once the police arrive, they make that interpretation on their own as to whether or not it's a crime. Once they've established some reasonable suspicion or probable cause to rise to that level of an arrest, if in fact they do whatsoever. But we can't stop people from calling. I think
That bias may exist with the officer showing up too, who inherently also feel that a certain type of person is more dangerous.
or it may not.
Mike, we have you here as the witness, so have you any other comments or concerns with the bill?
No, thank you. I appreciate it.
I think we've moved on to the markup stage. But thank you, Mike. Eric, you want to stay there, it's fine. Any comments from anybody who's online or here in the room? What we've been discussing so far. Devin, please feel free.
Thank you. Devin Green, Vermont Association of Hospitals and Health. And I just wanted to clarify on the amendment that John Wallace put forward. Right now, under HIPAA, hospitals cannot disclose that a patient's been discharged or that they're stabilized. So if they call in law enforcement for a crime, they can disclose things that have to do with the crime. And the interpretation of the law has been that discharge or stabilization is not a part of the crime. And so hospitals can't disclose that information. And so what this would do is create an exception with the state requiring disclosure of this information so that a healthcare provider can let law enforcement know that the person has been discharged or stabilized.
Can you speak to doctors' offices as well and other parts of a medical facility? For example, operating room or whatever. I suppose operating rooms are not, usually it's only the doctors in there and the patient.
Yeah, I will speak certainly for other parts of the facility. We had a witness who worked on the inpatient unit, and we actually often see assaults on, I think, mother-child units. If there's domestic dispute, assaults can happen there as well. But we have heard in doing this work, we've heard from the Vermont Medical Society in support of this because this is also happening in facilities. And you also heard from Allison Davis at Rutland Regional Medical Center about how the urgent care needed to be shut down because there was a patient assaulting people. And then once that urgent care was shut down, those folks, all the patients who were waiting in there had to be moved to the already overcrowded emergency department.
That's right. I remember that.
Thank you.
Anything else? Anyone else who wants to comment? Go ahead, Eric. Eric had a question for somebody.
Devin, can I ask you a question about this language?
Sure, and I may call on, I think John is gone, but yes, go ahead and ask.
I guess what I'm not following is that, why is it that the stabilization information needs to be passed along to the law enforcement officer? Presumably, the law enforcement officer wasn't going to get the call unless the hospital was of the point of view that there needed to be an arrest made. So they call the officer has to decide whether or not there's probable cause that whatever the committee ultimately decides if they want to go forward, which of those underlying offenses was committed. And if the law enforcement officer does have probable cause that was committed outside the presence, they could make an arrest. But is the suggestion that in the meantime, after the facility called the officer, that maybe the patient was stabilized? And so now the facility has changed their mind and they don't think the person should be arrested. So they want to be able to communicate that to the officer and say, actually, everything's okay. You don't need to arrest the person. Is that, and they feel they don't have the authority to disclose that now? Is that what this is about?
No, I think it was, so what we were hearing from law enforcement was that concerns that they did not want to remove an individual who wasn't stabilized and hospitals being unable to tell them that the person has been stabilized. And so this would allow hospitals to tell law enforcement that the person has been stabilized or discharged.
Gotcha. Thank you. That helps.
Well,
Understand it.
yeah. Wilda White has a comment or question or has her hand up, I should say.
Thank you, Senator Sears. For the record, my name is Wilda White, and I am a policy and training consultant with the Department of Public Safety. And this is related to the last exchange between Legislative Counsel in Devin Green. And I just wanted to underscore that, law enforcement is not going to remove a patient from the emergency department without knowing that the patient is stabilized and ready to be discharged. So this is just connected to why it's so important for that information to be communicated to law enforcement.
Sometimes just calling law enforcement will calm the situation down, by the way, and make an arrest unnecessary. Okay. Is there anything else, anybody else? Go ahead. Mike?
Sorry, I just want to add one thing. So stabilized doesn't mean that the person's no longer violent. I'm thinking of stabilized in medical terms. So if someone came in for a heart attack and the heart attack is stabilized, then they're able to be removed. I don't want folks to think stabilized means the person is calm. I think it's more of a medical term.
I think I should have used the term, the situation has been de-escalated to the point where arrest is no longer necessary. Just by simply calling law enforcement, sometimes that can make a difference, Wait till your father gets home used to make a difference in my home.
So I was just gonna chime in. I think that this additional language provided in this memo could be useful, and I think it should be incorporated into the bill as long as it's kosher with the law and HIPAA. And and as was just mentioned a minute ago, I mean, police aren't going to go in and remove somebody if they're not sure that they're medically cleared. They're not going to want that liability, and I think it makes it. Yeah, I think it makes it more clear for law enforcement as to what they can and can't do. Yeah, so I think it should be added.
I agree, and it should be added. I think it's important.
Yeah.
Safeguard. Or anything else? We did say we could vote today. Eric, do you want a few minutes to do a redraft, or do you want to?
With the proposed language added.
Yeah, I mean, is there any further testimony anybody wants, or feels we need before we can vote?
Well, I don't want to regret mentioning it or not mentioning it, but I feel like the disorderly conduct component keeps coming up as an issue.
Okay.
Is that something that we want to continue discussing? Should we remove it? Keep it simple assault and criminal threatening, or what are the thoughts there? I don't have an answer, but I feel like it keeps coming up.
The more we've discussed disorderly conduct, the more comfortable I've become with it, because it has the statement in the bill. I will go back to the bill and read. It's not, you have the language there, and you have disorderly conduct. That interfered with the provision of medically necessary healthcare services in a healthcare facility. So it's only disorderly conduct that interferes with the provision of medically necessary healthcare services. So it's beyond what's here, it's further narrow that it has to be doing that. So I don't, go ahead.
To Senator Hashim's points, with most of what that would be, if not all of what that would be, is already covered by simple assault, and I just think it leaves too much up to judgment. I don't feel comfortable.
So how is it covered? I don't, maybe I'm, yes, but I don't understand how it's covered by simple assault.
So, I was just brainstorming different situations here. I mean, I'm thinking that if somebody is being violent enough or tumultuous enough to the point where it's disrupting somebody else's medical care, that could be considered, threatening behavior in such a way that somebody's in fear of their physical safety. Or they could just be acting violent and tumultuous enough that somebody's getting hurt, which could also be a simple assault.
Yeah, but they haven't thrown a chair. They are screaming, they are yelling, they are, dominating, they keep pushing the little button to call.
Tearing curtains down off the wall or wherever it may be. I mean, where's the assault going to play? It doesn't.
Well, I mean, yeah, but that's one of my concerns, tearing the curtain off the thing. Yeah, it's disorderly, but does it rise to the level that that person needs to get put in handcuffs and taken away? Or if they're throwing a chair at another patient, that's assault. And they're interfering with access to care. If they're shouting repeatedly because they have a mental health issue or whatever
But
it
it has
is.
to interfere with necessary medical care for the other person. That's how it's narrowed. So it's not just tearing it down. My example of keep pushing the button for the nurse, and there's somebody who really needs the nurse,
Yeah, but
they can only be in one place at a time.
is somebody repeatedly pressing the button though, should they get arrested for that?
Well, at least somehow you gotta deal with it. It's taking away treatment to the other person, it's disorderly. If they repeat, I don't know, maybe yes.
So we assume they're going to get arrested, what you're saying.
If it rises to the level of interfering, I mean, if they commit a crime, then yeah, they're getting arrested, but.
They're merely getting, well, they may be getting arrested. We haven't even talked about what happens to them after they're arrested. It's just a removal from the hospital facility. It might be.
I'm just trying to hash it out, because I know it's a point that's been brought up a lot, and.
If you could I suppose you could further limit it. I don't know how,
I don't know either.
but I thought it was pretty well.
I mean, I will say that, I'm happy to vote on the bill. I would just express some reservations about the disorderly conduct, and perhaps the House would maybe have some more time to flesh through additional language.
Well, the Health and Welfare Committee's gonna look at it. Whether they take possession or not.
I think our concern here should be also that we should be concerned about the alleged violator. We also need to remember as to why we're looking at this bill, about the concern of the alleged victims in this particular instance too. So we do have to make sure that there's a balance between the two as to we protect both sides.
I agree.
Maybe. You could further narrow it to make clear it's. Yep, I'm sorry, Mike.
In the interest of trying to be helpful, Mike Fisher, healthcare advocate. Is it number 2 in disorderly conduct? That is one area that raises concern for me. Is it possible to include disorderly conduct A 1, 3, 4, and 5?
Well, I don't think you'd be obstructing vehicular
Right, understood. I'm trying to accept it, to focus on whether
Yeah,
number two.
I understand
Well, and when I look at it, really what we're talking about is number one, which is where I said I think most of that can be covered by simple assault, particularly if it is interfering with somebody else. Like, it's part of what I have a concern with.
So I guess I'm confused. We're looking at changing the disorderly conduct law and only applying certain portions of it to this, as it fits our desired needs?
No, I think
What's
we're
going on?
looking at how would you limit in the hospital setting, the application of the disorderly conduct statute. It's already been limited by medically necessary healthcare services. That it interfered, the person has committed a violation of disorderly conduct. And that you could read it, and that interfered with provision of medically necessary healthcare services in a healthcare facility.
I mean,
So the disorderly conduct, in order to be charged in this setting, would need to have interfered with provision of medically necessary. That's why I'm thinking it's already been narrowed.
right, I'm actually not suggesting we narrow it more. I'd like to see it taken out of the bill.
Understood.
Because I think what we're trying to get at with this narrowed language is already covered by simple assault.
But I don't think it is. The scenario that I gave, somebody's, monopolizing two nurses without assaulting anyone. There may be only 5 on duty. That means other people are not going to get necessary medical treatment.
Right, and I guess.
And monopolizing them by screaming, swearing, whatever else.
And I guess I just don't know that that person should be arrested. I mean, we're trying to deal with violence, and that to me doesn't rise to the level of violence.
I think we're gonna have a disagreement.
Yeah, I think we might.
So what we do usually is vote, but Senator Bruce not here to vote, so. Thinking it's 2-2. Or maybe.
I would vote for this as it's written, just with the on the record expression that I do have concerns about some of the provisions regarding disorderly conduct and the hope that it gets hashed out in the next committee that it goes to.
Yeah, I would not vote for this as it's written.
I would support the bill as written.
Right?
Do you want me to email Ashley to see if Senator Bruce can come back?
Yeah, see if we can come back at 11:30. Gives Eric enough time. How much time do you need, Eric?
I think I can do it by 11:30, only,
You want till 11:40?
yes, and
Why don't we come back?
what that number is, the
And we
proposal.
will ask Health and Welfare to look particularly at the disorderly conduct, working with the Hospital Association and others to look at that portion of the bill specific. They can look at everything, but asking Health and Welfare to look specifically at disorderly conduct. And the healthcare setting.
And the proposed language, because
And
that's
the
in the
new
healthcare.
proposed language.
That's the one thing, only concern I have is I want to make sure I run that by our healthcare attorneys. But if they're gonna look at it, there should be provide time to do that.
Comfortable?
Yeah.
Okay. Why don't we